Good morning. Please be seated. The sitting is open. The court meets today to hear oral arguments of the parties in the case concerning the Telders Centre dispute. Let me recall briefly the procedural history of the case. On July 3rd, 2016, Twiga instituted proceedings against Pundamilia. In its application, Twiga requests the court to adjudge and declare that by instituting proceedings against Mrs. Fisi, Pundamilia breached the immunity from jurisdiction and the inviolability enjoyed by her under international law, notably the Vienna Convention on Diplomatic Relations and Customary International Law. Further, by searching and attaching the premises of the Telders Centre, located at 22 Baobab Street in Savannah, which are the property of the Republic of Twiga and used for the purposes of its diplomatic mission in Pundamilia. Pundamilia breached its obligation under international law, notably the Vienna Convention on Diplomatic Relations and Customary International Law. The applicant further requests the court to order that the respondent ceases the ongoing proceedings against Ms. Fisi and recognize the status of the building located at 22 Baobab Street in Savannah as part of the premises of its diplomatic mission in Pundamilia and ensure its protection as required by international law. On July 10, the court adopted the order setting time limits for the parties to file their pleadings. On November 10, the court received memorial of the applicant, and on March 10, 2017, the counter memorial from the respondent. In that counter memorial, the respondent formulated the counterclaim, so the court provided a time limit for the applicant to file observations on counterclaim, which were duly filed on May 10. The parties agreed that there was no need for further written briefs. The court is thus ready for argument. I know the presence of the agents and counsel for both parties, and I now invite the agent for the applicant to present the arguments of the applicant. Please, you have the floor, sir.
Mr. President, honorable members of the court, my name is Nicholas Sabian, and I have the honor to appear before this court on behalf of the Republic of Twiga, alongside with my co-agent, Connor Keegan. I would like to reserve 90 minutes for my arguments, 18 minutes for the arguments of my co-agent, and a total of 3 minutes for our rebuttal. Your Excellencies, the case before this court concerns the failure of the respondent state to respect one of the most fundamental and oldest branches of international law, namely diplomatic law. It is precisely through diplomatic law that good relations and cooperation is ensured among states. In the case at hand, Your Excellencies, Mrs. Fisi, the wife of the ambassador of Twiga to Pundamilia, aimed to promote and develop cultural relations between the respective parties through the activities in the Twiga Cultural Centre. While carrying out these cultural activities, Your Excellencies, the respondent state instituted criminal and civil proceedings against Mrs. Fisi. We submit that these actions constitute a violation of the most essential rules of diplomatic law, namely the inviolability and immunity of diplomatic agents and their family members. Thus, it will be argued in Twiga's first submission that Pundamilia breached Mrs. Fisi's immunity from criminal jurisdiction by instituting criminal proceedings against Mrs. Fisi and indicting her on criminal charges. Even though Pundamilia made the reservation whereby it sought to restrict the absolute immunity from criminal jurisdiction of diplomatic agents and their family members, we submit that this reservation is impermissible and thus it remains without any legal effect. In Twiga's second submission...
Could you remind me of the text of the reservation you are invoking?
Certainly, Your Excellency. The text of the reservation can be found in paragraph 6 of the case, and it states that diplomatic agents and their family members enjoy immunity from criminal jurisdiction except in relation to professional or commercial activities. In Twiga's second submission, it will be shown that Pundamilia breached Mrs. Fisi's immunity from civil jurisdiction and her personal inviolability, which she enjoys as a family member of a diplomatic agent. Subsequently, my co-agent will proceed by showing that Pundamilia breached its obligations under the Vienna Convention on Diplomatic Relation and customary international law by searching and attaching the premises of the Twiga Cultural Center, and lastly, that Twiga is not responsible for the suspension of the military supply contract. If it may please the Court, I would like to start with our first submission.
Please proceed.
Thank you. Your Excellencies, Twiga asserts that Pundamilia breached its obligations under the Vienna Convention on Diplomatic Relations and customary international law by instituting criminal proceedings against Mrs. Fisi, as it is stated in paragraph 18 of the facts of the case. In the light of Article 37, paragraph 1 of the Vienna Convention on Diplomatic Relations, Mrs. Fisi, as a family member, enjoys the same privileges and immunities as diplomatic agents. Therefore, she enjoys absolute immunity from criminal jurisdiction according to Article 31, paragraph 1 of the VCDR. Therefore, we submit that the institutions of criminal proceedings against Mrs. Fisi violated her immunity from criminal jurisdiction. As regards the reservation, which aimed to restrict this absolute immunity from criminal jurisdiction of diplomatic agents and their family members, we submit that it is incompatible with the object and the purposes of the Vienna Convention on Diplomatic Relations. Now, as it is stated in Article 19 of the Vienna Convention on the Law of Treaties, which reflects customary international law, the reservation can be made unless a treaty prohibits a reservation to be made, or only a specific reservation can be made, and unless it is incompatible with the objects and the purposes of the VCDR, of a specific treaty, in our case, VCDR. Since the Vienna Convention on Diplomatic Relations remains silent on the issue of...
May I interrupt you? Judge Infante-Cali would like to put a question to you.
Yes, I would like
you have the floor,
question.
madam.
Thank you. I would like to ask you if your country object to this reservation.
Your Excellency, Twiga did not object to the reservation. Nevertheless, we submit that the permissibility of the reservation precedes its acceptance. Therefore, an impermissible reservation cannot be cured subsequently by the acceptance of a state. More precisely, we submit that this court should assess the permissibility of this reservation, as it did, for instance, in the armed activities case in 2006 between the Democratic Republic of Congo and Rwanda, in paragraph 67. Returning back to the issue of permissibility of the reservation, we first have to outline the objects and the purposes of the Vienna Convention on Diplomatic Relations. These can be found, as this court has stated previously, for instance, in the preamble of the treaty. It was stated by this court in the 1986 Nicaragua case in paragraph 275, or in the advisory opinion on the Reservations to Genocide Convention in paragraph 23. The preamble of the VCDR states that the privileges and immunities contribute to the development of friendly relations between nations, and they ensure the efficient performance of diplomatic functions. Furthermore, the privileges and immunities have a functional aim. Therefore, they ensure the independence of diplomatic agents while carrying out their activities. Hence, the privileges and immunities enshrined in the VCDR, namely the absolute immunity from criminal jurisdiction of diplomatic agents and their family members, is essential for the functioning of the treaty and it remains the core of the VCDR. It is not only a customary norm of international law which has been established even before the existence of the Vienna Convention on Diplomatic Relations, but it remains essential to ensure the independence of diplomatic agents and the efficient performance of diplomatic functions. Therefore, the absolute immunity from criminal jurisdiction is inevitable to ensure the objects and the purposes of the VCDR. Nevertheless, the reservation made by Pundamilia, will significantly impair this long-established rule of international law and would frustrate its importance. It would be against the very... Yes?
I give the floor to Judge Reh as a question. Please, yeah, proceed, sir.
But on that question, if Ms. Fissi was carrying out commercial activities, how could the reservation by Pundamilia be considered compatible with that, or incompatible with that?
Your Excellency, we submit that the reservation itself is incompatible with the object and the purpose of the Vienna Convention on Diplomatic Relations, and therefore it remains without any legal effect. And thus, Mrs. Fissi enjoys absolute immunity from criminal jurisdiction, and Pundamilia breached its obligations under the VCDR, namely Article 31, Paragraph 1 of the VCDR.
The point I'm asking you is about if she's carrying out commercial activities, which is already exempted under the convention, why would the reservation be incompatible if that's part of the case?
Well, we have, as I have outlined, the objects and the purposes of the VCDR. So the efficient performance of diplomatic functions, the contribution to the friendly development of between nations. This is what we have to assess. We have to assess whether the reservation itself, the limitation upon the absolute immunity from criminal jurisdiction, is compatible with the object and the purpose of the VCDR. And we submit that it is not. And we submit that it remains without any legal effect, and Mrs. Fissi enjoys absolute immunity from criminal jurisdiction. Moreover, even though it is not prohibited to make reservations to provisions which reflect customary international law as immunity from criminal jurisdiction, the International Law Commission observed in its guidelines on reservation to treaties from 2011 that due account must be taken of that element when assessing the permissibility of the reservation. We therefore submit that the reservation...
What do you have in mind by due account when you consider permissibility of reservation? What is the due account?
Well, Your Excellency, we understand that the language of ILC in this respect has been rather vague, but...
It will be for this court to elaborate, yeah, or to clarify in its judgment, yeah?
Yes, Your Excellency, that would be the case.
Thank you. Thank you for that, respecting the role of the court in developing international law. Please proceed.
The Stwiga respectfully submits, Your Excellencies, that the reservation made by Pundamilia is incompatible with the object and the purpose of the VCDR, and it remains without any legal effect. Unless there are any further questions with respect to our first submission, I might move to our second submission. Thank you.
Please proceed to the second submission.
Under Twiga's second submission, I will address two issues. Firstly, we submit that Pundamilia breached Mrs. Fissi's immunity from civil jurisdiction by instituting civil proceedings against her. And secondly, that Pundamilia breached Mrs. Fissi's personal inviolability by issuing a summons to her. With respect to the first issue, the issue of immunity from civil jurisdiction, we submit that the activities undertaken by Mrs. Fissi were neither commercial nor professional. On the contrary, Your Excellencies, these activities were part of the Twiga's diplomatic mission. Namely, they can be subsumed under Article 3(1)(e) of the Vienna Convention on Diplomatic Relations, and that is the promotion of cultural relations between the sending and the receiving state. Twiga claims that the activities within the context of the Twiga Cultural Centre are part of the functions of Twiga's diplomatic mission due to the following considerations.
I give the floor to Judge Infantegali for her question.
Thank you, Mr. President. I would like to ask you about the nature and the scope of these activities that were conducted in the Cultural Centre. You say that the mission, or part of the mission of an embassy is to develop cultural relations. Yes. But the question of commercial activities related to that have been subject to special considerations in another legal court, which is about immunities. Can you make, an argument around that?
Certainly, Your Excellency. I was just about to proceed to argue why these activities were cultural. So we submit that the main functions of the Twigan Cultural Centre were the free exhibitions of Twigan's paintings, sculptures, and also artistic workshops on the traditional Twigan painting technique, with the objective to promote cultural relations between the respective parties, as it is stated in paragraph 9 of the facts of the case. Although her activities involved a sale of paintings, we submit that the diplomatic functions on one hand and commercial activities on the other hand are not mutually exclusive. Moreover, we submit that even though there was a commercial benefit by Mrs. Fisi, the UK Court of Appeal in the Reyes versus Al-Maliki case in 2015 stated that even though while diplomatic agents are carrying out their functions and it involves a commercial benefit, it doesn't necessarily mean, it doesn't automatically mean, that these activities are commercial per se. It was also
how would you reconcile your submission about the role of the diplomatic mission to promote cultural relations between the two countries, that this cultural center and Mrs. Fisi was also promoting and selling artwork from artists from Kima?
Your Excellency, with this respect, we would like to point out that, as is stated in paragraph 13 of the facts of the case, there were totally 100 paintings or artistic items in the cultural center, and merely 2 of those, there were merely 2 sculptures from the neighboring state of Kima. Therefore, we submit that these 2 sculptures cannot deprive this Twigan Cultural Center a commercial role, and it cannot deprive the promotion of cultural relations between the sending and the receiving state. While Mrs. Fisi was carrying out these activities, she was relying on the services of the diplomatic mission. She was using the security services, the printing facilities of the mission, and moreover, she was using the telephone of the Twiga's diplomatic mission.
I have a further question. I understand that Mrs. Fisi was notified to the Foreign Ministry in Pundamilia as a wife of the ambassador, yes. Not as cultural counselor. What are the functions of a wife of the ambassador? Because in relation to immunities from civil jurisdiction, of course, this is except for acts outside of the professional, outside of the official functions. That means not for professional or commercial activities. Yeah? Could you elaborate on that? Functions of a spouse of the ambassador?
Well, the spouse of the ambassador doesn't have, of course, diplomatic functions to carry out, as it is clear from the Vienna Convention on Diplomatic Relations. Nevertheless, she may have been carrying out these activities within the Twigan Cultural Center as part of the Twiga's diplomatic mission. And furthermore, it was made by a joint statement by Twiga's Minister of Foreign Affairs and the Ministry of Defense in paragraph 23 of the facts of the case, that Mrs. Fisi was carrying out the functions of Twiga's diplomatic mission.
So you argued estoppel, yeah?
Pardon?
Are you arguing estoppel?
No, Your Excellency, we do not.
Okay, thank you.
Thank you.
That's right.
Yes. I have a question on that one as well, because it appears that it's quite a cosy arrangement she has going on here, where there's a 70-30 split. She gets 70% and the embassy gets 30%. How's that compatible with her official functions as a diplomatic agent?
We do understand your concerns, Your Excellency. Nevertheless, we would like to point out that the 30% was merely the repayment for the services, and the 70%, and the facts of the case remain silent on what Mrs. Fisi was using those 70%. It is not stated in the facts that she actually went on and bought the sculpture, which she intended to buy. And furthermore, even the fact that she was returning only 30% of the proceeds, this is to a certain extent an indication that these activities were part of the diplomatic mission. And as I have mentioned earlier, Your Excellencies, even though there was a commercial benefit while carrying out the cultural activities, as it was concluded by the Reis versus Al-Maliki case by the UK Court of Appeal, this doesn't mean that the activity itself is commercial.
What about if it is found that the Van Tembo paintings are in fact forged, and the wife of the ambassador has been involved in selling forged paintings and keeping 70% of the proceeds? Would you still be arguing that's compatible with her official duties?
If it were to, Your Excellency...
If it were to be established that the Van Tembo, the magnificent paintings, were in fact forgeries, and the wife of the ambassador is involved in selling these forgeries from the neighbouring country, Kima, which doesn't seem to be that connected with Twiga on the facts, would your stated position still be that that falls within her official capacity as a diplomatic agent?
Well, if it were turned to be out that there were more paintings or artistic items from the neighbouring country of Kima, this would mean that the Article 3.1e of the VCDR, namely the promotion of cultural relations between the sending and the receiving state, would not be fulfilled. Nevertheless, as I have mentioned earlier, there were merely 2 sculptures from Kima from the...
Let's proceed. In view of the number of questions put by the bench, you have some 3 minutes to complete the argument. Yeah, your submission, please.
Thank you. Thank you very much, Your Excellency. I would like to turn to the issue of personal inviolability of Mrs. Fisi. We submit that the issuance of summons to Mrs. Fisi, as it is stated in paragraph 18 of the facts of the case, violated her personal inviolability, which she enjoys under Article 29 of the VCDR and customary international law. Even though Article 29 of the VCDR doesn't explicitly state that a summons might be in contravention of this article, we submit that the summons issued to a diplomatic agent or their family members is a manifestation of the enforcement jurisdiction of the receiving state. Therefore, we submit that this summons issued by Pundamilia was in breach of Mrs. Fisi's inviolability, which she enjoys under Article 29 of the VCDR and customary international law. Your Excellencies, unless there are any further questions with respect to Twiga's first 2 submissions, I would like to give the floor to my co-agent, who will proceed with Twiga's 3rd and 4th submission.
Thank you very much, Excellency, and I call now on the co-agent.
Thank you very much for your kind attention.
I give him the floor.
Mr. President, honourable members of the court, my name is Conor Keegan and I would like to continue the case for the applicant. I will proceed by arguing 2 points. Firstly, that the respondent, Pundamilia, breached its international obligations under both the Vienna Convention on Diplomatic Relations and customary international law by searching and attaching the premises of the Twiggan Cultural Centre. Following this, I will proceed to present the final argument on behalf of the applicant. That is, that Twiga has not breached an international obligation under the Military Assistance Agreement because the actions of Twiggan Helicopters Incorporated cannot be attributed to the state of Twiga. Your Excellencies, I would like to start with the applicant's third claim. I will proceed to show that on the relevant date, the 13th of January 2016, when the premises of the Twiggan Cultural Centre were raided by the authorities of Pundamilia, it was performing the official functions of a diplomatic mission. Secondly, even if this court should decide that the premises of the Twiggan Cultural Centre and the premises of the Twiggan Diplomatic Mission are not one whole building, there is nothing in the Vienna Convention on Diplomatic Relations which precludes diplomatic missions from being located in a number of buildings. Finally, and furthermore, it will be submitted that Twigga was not under any obligation to notify Pundamilia of an expansion to its diplomatic premises. These points will lead to the conclusion that the premises of the Twiggan Cultural Centre are inviolable and that that inviolability was breached when they were raided by the authorities of Pundamilia. Your Honours, let me begin by quoting the wording of Article 1I of the Vienna Convention on Diplomatic Relations, which defines diplomatic premises as, quote, buildings or parts of buildings and the land ancillary thereto, irrespective of ownership, used for the purposes of the mission, end quote. This provision places the main emphasis on the use or the function of the building in question. As my co-agent referred to, Article 3.1e of the Vienna Convention on Diplomatic Relations provides that diplomatic functions include the development of cultural relations between the sending and the receiving states. As an example, American corners in the US embassies around the world, including the British Information Service in New York City and the South African Information Service in Los Angeles, have received consular protection under Article 5b of the Vienna Convention on Consular Relations, which is itself based on Article 3.1e of the Vienna Convention on Diplomatic Relations, and which was confirmed to be customary international law by this court at paragraph 45 of the Terran Hostages Judgment.
And I assume that these information offices were notified to the State Department. Has Twigga notified the opening of the Cultural Centre to the authorities of Pundamilia, to the Foreign Ministry of Pundamilia?
As Twigga notified Pundamilia? Yeah. Well, I will proceed to show that there is no requirement of notification in the absence of national legislation.
You refer to the UK practice in the United States, so I expect that the United Kingdom notified State Department of the opening of information offices in New York and LA, or cultural offices in New York and LA.
Yes, Your Excellency, these particular information centres were established, but however, they preceded the acts which were passed in both the United Kingdom and the United States, which it is submitted does require that notification takes place. And where there is national legislation, that notification should occur. It also should occur where there is a bilateral agreement between the sending and receiving states to have such a notification. However, in the clarifications to this particular case of the Twiggan Cultural Centre, we are told that clarification 8, that the national law of Pundamilia does not require such a notification, and that in clarification 2, that no bilateral agreement exists. And while in the Harvard draft on diplomatic privileges and immunities, there was some moves towards a requirement for notification, these were not included in the subsequent Vienna Convention on Diplomatic Relations, which is now the authoritative document in this regard. In relation to, just to return for a moment in relation to the functions that were taking place at the Twiggan Cultural Centre, in clarification 14 to the facts of this case, the premises of the Twiggan Cultural Centre are acknowledged to be performing, and I quote, the typical functions of a diplomatic mission, end quote. Therefore, Twigga submits that by establishing the Twiggan Cultural Centre to contribute to the promotion of cultural exchanges between Twigga and Pundamilia, as is provided by paragraph 9 of the facts of this case, conducting activities such as the displaying of works of Twiggan artists in the receiving state, which is detailed in paragraph 10 of the facts, and hosting free workshops on the traditional Twiggan painting technique, promoting Twigga's vivid artistic and cultural scene, we promote that the activities that are conducted at the Twiggan Cultural Centre are manifestly those of the cultural function of a diplomatic mission, and so therefore it receives diplomatic protection.
Judge Infante Cali would like to put a question to you, sir. You have the floor, madam.
But I would like to recall that there are criminal proceedings because there were some forged or fake objects being sold in the cultural center. So even if the status of the cultural center is such that it is protected under the law of immunity or inviolability, but the question is if the activities conducted in the center are also covered by that protection. So there is a distinction in the Vienna Convention on diplomatic relations too.
Yes, but, thank you, Your Excellency. We would argue that the decisive factor here in relation to diplomatic premises and buildings is the functions that take place therein. And so therefore, due to the elements of the particular facts that we've been given that I've just outlined, we would submit that the Twickenham Cultural Centre is performing those cultural functions and therefore receives the protection of diplomatic law as a result. In relation to the 30%...
I will still interrupt you since Judge Ray would like to ask a question. You have the floor, sir.
Point. Without Twiga notifying Pandemilia, how is it supposed to know that those premises are a cultural centre when essentially they're being used for the sale of artworks? On a practical example, in Utrecht here, there's an Australian Aboriginal art gallery. There's a flag out the front, an Aboriginal one, an Australian one. I'm Australian. Now, how is the Dutch government supposed to distinguish between that as a cultural centre of the Australian government and that as a private gallery? It's analogous.
That the Twickenham Cultural Centre was part of the Twickenham diplomatic mission. Subsequent to the purchase of the Twickenham Cultural Centre by the state of Twiga, the flagpole on which the Twickenham flag was flown was moved to the door of the Twickenham Cultural Centre, and also the plaque which detailed that it was the Twickenham diplomatic mission was also moved to the door of the Twickenham Cultural Centre. As therefore these visible indicators, although not decisive in this regard, are more indication. And furthermore, when the property was purchased by Twiga, it was also registered in the National Property Registry Authority of Pandemilia. As therefore they received some notice as to the fact that this was part of the diplomatic mission, Furthermore, Your Excellencies, there is nothing in Article 1I which precludes that diplomatic missions be located in a number of different buildings. And so therefore, even if those visible indicators were not decisive, or were not indicative, of the fact that these former two buildings are now one whole, there is nothing in the Vienna Convention on Diplomatic Relations which precludes diplomatic premises from being located in a number of buildings. Therefore, Your Excellencies, if we draw these points together, the functions being performed in the Twickenham Cultural Centre, the non-requirement of notification in this regard, and the fact that they do not have to be in contiguous buildings, we can conclude that under Article 22.1, the premises was inviolable when it was raided by the authorities of Pandemilia, and so therefore the inviolability of Twiga was breached by that state. Furthermore, Article 22.3 of the Vienna Convention on Diplomatic Relations provides that any property on inviolable premises, any property on inviolable premises is also inviolable. And so therefore, even though the painting which was seized by the authorities of Pandemilia was not owned by the state of Twiga, this is also a breach of the inviolability because Article 22.3 protects any property which is on that particular premises. If there are no further questions on this third submission of the applicant, Your Excellencies, I might proceed to the final submission of the applicant.
Yes, please proceed.
Thank you, Your Excellency. Your Excellency, Twiga respectfully submits that it is not responsible for the suspension of the contract which was agreed between a private company, Twiga Helicopters Incorporated, and the state of Pandemilia. In order to make Twiga responsible for the actions of a private company, it would be necessary first to attribute any breaches from that private entity to the state of Twiga. In this particular case, we will argue any avenues of attribution are not proven out. The most relevant avenues of attribution we would argue in this regard are the avenue under the Articles on the Responsibility of States for Internationally Wrongful Acts, Article 11 of that particular agreement, which
these are just draft articles.
That is correct.
Should we apply draft articles which have not been adopted by member states of the United Nations?
That is correct, Your Excellency. These are merely articles and an agreement, but not a binding treaty. However, they are reflective of customary international law in general, and the Article 11 is reflective of the decision of this court in the Tehran hostages case, as therefore it represents that standard. The other avenue that might be open here would be that Twiga Helicopters Incorporated was under the instruction, direction, or control of the state of Twiga, and therefore the attribution can be possible under the Articles on the Responsibility of States, Article 8.
I'll interrupt you. Madame la Juge Infante Cali would like to put a question.
Thank you. Thank you, Mr. President. I would like to ask you the following. Well, how do you interpret, how do you understand the statement made by the two ministers of Twiga, saying that the helicopters, the delivery of the helicopters of the sale was suspended, so there was not a priori authorization, but it may have happened something after the decision of the company?
Yes, Your Excellency, and this is precisely the type of attribution that would happen under Article 11 of the Articles of Responsibility of States. However, we would argue that the statement of the ministers does not constitute the clear and unequivocal endorsement which was decided by this court in the Tehran hostages case as being necessary for attribution to occur under that article. Furthermore, the International Criminal Tribunal for the former Yugoslavia, in its Nikolic case, provided that the state attribution cannot occur to the state because it is a mere beneficiary of a particular situation. We would argue that the statement of the ministers in this particular regard does not mention either the military assistance agreement or the contract that was agreed between Twiga Helicopters Incorporated and Pundamilia. Furthermore, the statement, the particular paragraph of the facts refers to the fact that the contract was suspended, but it does not say in any definitive way how this occurred. But because the contract was between the private company of Twiga Helicopters Incorporated and the private state, and the state of Pundamilia, we would argue that there is no attribution in that particular regard. That there is not that clear and unequivocal standard which was enunciated in the Tehran hostages case and then which was subsequently enshrined in the Articles on State Responsibility.
Judge Ray has a question for you, sir.
Yes.
To follow up on the question that's just been asked in your answer, the point you're not addressing is the fact that the Minister of Defence is the brother of the ambassador's wife. Looking at it from that perspective, why wouldn't we be entitled to view that these are disproportionate countermeasures in which there's a bit of personal gain thrown in?
We would submit, Your Excellency, that in the statement which the Minister made, he was acting purely in his capacity as the Minister from Pundamilia and not in a personal capacity as the brother of Mrs. Fizzi. And so therefore, this necessary link of attribution is not proven out by that particular statement. It is a mere acknowledgement of a factually existing situation.
We'll continue with the argument. You have some 3 minutes left.
The other avenue that might be open here, Your Excellencies, is under Article 8 of the Articles of State Responsibility for Internationally Wrongful Acts, which is instruction, direction, or control of a particular entity by a state. It was held in this court, again in the Tehran hostages case, that instruction, in this particular regard, must constitute a clear manifestation of the will of the state authorizing unlawful acts. Furthermore, to exercise direction or control, the state must use its position to authorize specific acts rather than vague or generally defined activities. And so therefore, the test which this court has of course applied in the Nicaragua case and then subsequently in the genocide case of effective control over particular actions of the entity is not proven out in this particular case. We've seen nothing that would make that link between Twiga Helicopters Incorporated and the state of Twiga. And so therefore, in this regard, because that effective control test is something more than organising, equipping or controlling, even if there was that level of control in this particular regard, that is not proven out.
Thank you. So is your submission that this court was correct both in Nicaragua in genocide case and the criticism of ICTY is unjustified, yeah? in Tadic.
Not to flatter the court, Your Excellency, but yes.
Please continue.
Thank you, Your Excellency. So therefore, we submit that because on either of these avenues of attribution, there is no proof that there is a link between Twigan Helicopters Incorporated and the state of Twiga, there is therefore there cannot be therefore any resort to lawful countermeasures in this regard. That the first thing that must be proven in any regard is that there is attribution, then going on to the breach, and then all those considerations of pacta sunt servanda and countermeasures come after that. Your Excellencies, if you're satisfied with what I've submitted and you have no further questions, I might proceed to the submissions of the applicant in this regard.
Certainly, please.
Thank you.
Go ahead.
Thank you. Mr. President, honourable members of the court, this case, entails an attempt by Pundamilia to subvert diplomatic law, as well as a flagrant breach of the inviolability and immunity, and an effort to link the government of Twiga to actions in which it had no hand, act, or part. In light of the grave breaches that have been committed, and the attempts to ruin the good name of the state of Twiga, Twiga requests that this court adjudge and declare that, firstly, Pundamilia's statement, which has been appended to the Vienna Convention on Diplomatic Relations, is without legal effect. Secondly, that Pundamilia breached Mrs. Fizzi's inviolability and immunity from civil and criminal jurisdiction under the Vienna Convention on Diplomatic Relations and customary international law, since she's a family member of a diplomat. Thirdly, that Pundamilia breached its obligations under both the Vienna Convention on Diplomatic Relations and customary international law by searching and attaching the premises of the Twigan Cultural Centre. And finally, that Twiga has not breached a provision of the Military Assistance Agreement because the necessary attribution is not present in this case. Your Excellencies, if there are no further questions, I'd like to thank you for your attention.
Okay, thank you very much. We have no more questions. This completes the first round of arguments by the applicant. You can take your seat, sir.
Thank you, Your Excellency.
And now I invite the agent or the respondent, Pundamilia, to address the court. Madam, you have the floor.
Mr. President, honourable members of the court, my name is Lisa Kuyus, agent for the respondent, and I have the honour to argue on behalf of the Republic of Pundamilia. May I introduce my co-agent, Tobias Meyer. Your Honours, I would like to reserve 22 minutes of our time for my argument, 50 minutes for my co-agent, and a total of 3 minutes for our thorough rebuttal. Within the scope of Pundamilia's first claim, I will show that by instituting proceedings against Mrs. Fisi, Pundamilia did not breach its immunity from jurisdiction and inviolability enjoyed by her under international law. I will then proceed to establish within the scope of Pundamilia's second claim that by searching and attaching the premises of the Twigan Culture Centre, Pundamilia also did not breach its obligations under international law either. My co-agent will address the respondent's counterclaim by establishing that Twiga breached its obligations under the Military Assistance Agreement without justification. If it may please the court, I would like to start with our first claim.
Thank you, and please proceed.
In the present case, Mrs. Fisi does not enjoy immunity from civil jurisdiction under Article 31, Paragraph 1, Sentence 2 of the Vienna Convention on Diplomatic Relations. The applicant claimed that Mrs. Fisi did not engage in a commercial activity outside official functions. However, I will proceed to establish that this is not the case. The ordinary meaning of commercial is the exchange of goods and services. Your Honours, as simple as that, the relevant facts leave no doubt that Mrs. Fisi sold artwork in exchange for money. Accordingly, her activity embodies commerce in its most ordinary meaning. Over the course of 1 year, Mrs. Fisi then steadily increased the sale of private artwork and put half of her private exhibition, at least 50 pieces, on sale. This goes to show that she repeatedly, but also continuously used the Twigan Culture Centre as a trading place for artwork, and her activity was not just a single act of commerce. Therefore, Mrs. Fisi clearly engaged in a commercial activity.
Thank you. Madam, I'll interrupt you in order to give the floor to Judge Infante Cali. You have the floor.
Thank you, Mr. President. My question is about the not the participation, but the awareness that your country may have had, and regarding the activities that were conducted in the Cultural Centre, because those were public activities, and your government did not react, did not say anything. So there was a kind of acceptance. What do you say about that, this?
Your Honor, the government of Panameliya could not have possibly accepted or implicitly accepted the activities going on in the Tweigen Culture Center, as the activities were never notified to the Panamelian government or any state officials of the Panamelian head of government. In the present case, especially Mrs. Fizi's activities in the Tweigen Culture Center, which is not part of the diplomatic mission in Panameliya, were never notified and therefore do not constitute official functions, which I'm now going to elaborate further on. Moreover, it wasn't inside official functions for Mrs. Fizi to engage in a commercial activity. The applicant claimed that Mrs. Fizi promoted cultural relations and therefore exercised the function of a diplomatic mission. However, this is clearly refutable. In particular, selling the Kieman paintings in question from a third state could not have possibly contributed to the cultural exchange between the sending and receiving state, which is Tweigen and Panameliya, but not Kima. In reference to the Vienna Convention on Diplomatic Relations itself, a commercial activity outside official functions has been characterized as a business or trade activity, not incidental to the daily life of a diplomat, to realize a personal benefit. Such an interpretation, for example, has also been provided by the United Kingdom Court of Appeals in Propin Finan versus Singh, and also the United States Court of Appeals in Tabian versus Mufti. Mrs. Fizi, in the present case, kept the clear majority of the proceeds, namely 70% of the artwork, in order to purchase a sculpture for her private country house in Panameliya. Especially the Van Temple paintings considerably increased Mrs. Fizi's proceeds, and it is not apparent why a Tweigen Culture Center would display and also sell popular Kieman art if not for commercial interests. This clearly provides that Mrs. Fizi's interest with the Tweigen Culture Center was due to her own personal interest, as the sales activities in a private culture center are nowhere to be incidental with the daily life of a diplomat. While the sole purpose of granting privileges under the Vienna Convention on Diplomatic Relations is to preserve the functionality of the diplomatic mission, its preamble at the same time expressly emphasizes it is not to benefit individuals. On that account, it has been established in state practice, for example, by the United States Court of Appeals in Swarna versus Alvari, that every activity which primarily serves a private need cannot fall inside official functions of a diplomatic agent, even if at some point mission-related tasks are incidentally fulfilled within their course. I would lastly like to stress that the applicant cited Reyes versus Almaki in saying that not every commercial activity precludes a official functions in the very case. But this very court held in the same case that private income from private investments made by the diplomatic agent in the receiving state are not fruits of the activities that are incidental to the daily life of a diplomat and therefore are extraneous to it. To conclude, the activities of Mrs. Fizi could not have possibly contributed to the cultural promotion cited in Article 3 of the Vienna Convention on Diplomatic Relations, and therefore Mrs. Fizi did not exercise official functions of the diplomatic mission. Therefore, Mrs. Fizi also does not enjoy immunity from civil jurisdiction under the Vienna Convention on Diplomatic Relations.
What we are interested in is criminal jurisdiction, immunities
Yes.
from criminal jurisdiction. Could you elaborate a little bit on that,
I'm now going to proceed to establish that in the present case, with regards to the management of the Tweigen Culture Center, Mrs. Fizi also does not enjoy immunity from criminal jurisdiction under Article 31, Paragraph 1, Sentence 1 of the Vienna Convention on Diplomatic Relations. The reservations...
Judge Ray, you have the floor.
But who raised this with the other side, the applicant? What about the flag and the plaque outside the cultural centre? Isn't that the greatest indication to the raiding police that maybe they should stop at the door, exercise some caution, maybe make a phone call to the foreign ministry?
Your Honor, firstly, I would like to emphasize that the entering of the Tweigen Culture Center and the search and attachment relate to Article 22 of the Vienna Convention on Diplomatic Relations and the inviolability of diplomatic premises, or the possible inviolability of diplomatic premises. In the present case, the outside appearance is that nowhere to be found a determining factor for the establishment of a protected status of diplomatic premises, as Article 1 of the Vienna Convention on Diplomatic Relations solely cites that it is the purpose of the diplomatic premises which are to be established within the functions of a diplomatic mission. The provision contained in the Vienna Convention on Diplomatic Relations itself, which allows a diplomatic mission to carry a flag and also an emblem, was implemented into the Vienna Convention on Diplomatic Relations and also emphasized while drafting the Vienna Convention on Diplomatic Relations, as many countries had restrictions upon the rights to carry a flag and the right to carry an emblem. So it was a manifestation of such a right to carry a flag, but at no point a determining factor in order to establish the status and the protection of a diplomatic premise.
But on that issue of notification to your government as to whether the premises were being used for diplomatic purposes or not, there is customary international law is silent on this point, isn't it, as to whether there's an obligation to notify a receiving government of every outhouse or building or room that could be used for diplomatic purposes.
Yes, while the Vienna Convention on Diplomatic Relations does not provide for a provision itself as to the commencement of inviolability, its preamble at the same time expressly emphasizes every single provision which is not governed by the Vienna Convention on Diplomatic Relations itself continues to be governed by customary law. And a requirement to apply for the consent of the receiving state by the sending state is constituted in customary law. As, for example, the U.S. Foreign Missions Act provides for a provision which says the secretary should require any foreign mission to notify the secretary prior to any acquisition on behalf of such mission. And furthermore, the International Law Commission addressed such a problem in several reports, and Mr. Ago, a member of the International Law Commission, also said there is established practice that the sending state is notifying the receiving state in order for the receiving state to fulfill its duties and obligations under the Vienna Convention on Diplomatic Relations itself, which is the most important duty to protect the premises of the mission. And how would the receiving state protect the premises if not for a notification? Coming back to my argument as towards the immunity from criminal jurisdiction within the Vienna Convention on Diplomatic Relations. The reservation submitted by Pandamelia exempts, inter alia, commercial activities from the scope of immunity from criminal jurisdiction. In the present case, we have established in the course of the first claim that Mrs. Fisi engaged in such commercial activities and therefore falls within the scope of application of the reservation. May I turn this Court's attention to the very Article 4 of the Vienna Convention on the Law of Treaties?
May I draw your attention, I apologize, to the formulation of what your government stated when signing the Vienna Convention on Diplomatic Relations and subsequently confirmed when depositing instruments of ratification. And your government stated that it considers that Article 31 are to be interpreted as granting a diplomatic agent members of his family immunity from criminal jurisdiction of the receiving state, except in relation to professional or commercial activities. So this is about interpretation, because you expressis verbis use the term. That these articles are to be interpreted.
Pandamelia submits that the reservation submitted to the Vienna Convention on Diplomatic Relations is not a mere interpretive declaration of the government of Pandamelia, as in the articles and the draft articles of 1962 to the Vienna Convention on Law of Treaties. The International Law Commission stated that a reservation is a unilateral statement made by a state whereby it purports to exclude and vary the legal effects of certain provisions of the treaty in their application. Now, the provision contained in Article 31, Paragraph 1, Sentence 1 is absolute immunity from criminal jurisdiction without exceptions. So by submitting, upon signing the treaty text and also ratifying the Vienna Convention on Diplomatic Relations and exempting commercial activities from a norm which priorly did not have any exception to it, Panamalia definitely modified the treaty effects to that very convention.
Please, Judge Infante Cali, you have the floor, madam.
Well, I would like to ask you the following. Yes, the applicant has asserted that it is, they have not accepted this reservation. So what can you say to this assertion in terms of your own defense and defending these ideas about this real reservation?
Mm-hmm. In the present case, I want to turn the Court's attention to the very fact that the Vienna Convention on the Law of Treaties, which the applicant applies in order to apply the object and purpose test, says in Article 4 that the Convention lacks retroactivity, which means that it is not applicable for treaties priorly conducted to the Vienna Convention on the Law of Treaties. In the present case, therefore, the reservation submitted by Panamalia is solely governed by rules which constitute customary law in 1961 and 1962, since the Vienna Convention on Diplomatic Relations was signed in 1961, but the Vienna Convention on the Law of Treaties only entered into force in 1980, but not in 1961. Now, in the present case, the customary law governing the Vienna Convention on Diplomatic Relations required Twyge's consent for the prerequisite to the effectiveness of the diplomatic mission. Twyge ratified and signed the Vienna Convention on Diplomatic Relations prior to signing and ratifying, and actively refrained from objecting to the reservations submitted by Panamalia. Your Honours, with your permission, I doubt that Twyge wouldn't object to a reservation which it really considers incompatible with the object and purpose of a convention. This means that Twyge tacitly accepted the reservations submitted by Panamalia, and the reservation is thus also valid.
Thank you. Would your government accept that in case that the diplomatic agent or member of his family in Twyge is involved in some commercial or professional activities, in particular a family member, because most likely diplomats would not have time for that, that person can be prosecuted criminally in Twyge?
In the present case, upon signing...
Not only in the present case, generally.
In general, Panamalia submitted its reservation upon signing the treaty text and thereby clearly displayed its stance towards absolute immunity from criminal jurisdiction. And every single state after that reservation was filed had the treaty text with the reservation implemented to the Vienna Convention on Diplomatic Relations. And I want to emphasize that the Vienna Convention on Diplomatic Relations has several reservations being filed to the very convention, and every state which considered the reservation to be incompatible with the object and purpose, or which it didn't consider to constitute a principle of international law that they would comply with, objected to such reservations.
So in other words, your government is not going to claim absolute immunity for your diplomats in third countries if they are prosecuted for commercial or professional activities, yeah?
Yes.
Okay, thank you. Because there is a basic principle in diplomatic law of reciprocity. Yeah, thank you.
Therefore, Mrs. Feasy, as the reservation is valid and she falls under the scope of exception to the reservation, she does not enjoy immunity from criminal jurisdiction under the Vienna Convention on Diplomatic Relations. In the following, I will now establish that by issuing a summons to appear before preliminary examination, Panamalia also did not violate Mrs. Feasy's inviolability. Article 29 of the Vienna Convention on Diplomatic Relations prohibits arrest and detention, and therefore clearly depicts the principle of inviolability as one of a compulsory nature. The summons asking Mrs. Feasy to appear before an investigating judge did not contain any warning or threat, and Mrs. Feasy was never compelled to attend court after she refused to comply. This very court held in questions of mutual assistance that a mere invitation to attend a hearing does not amount to a breach of inviolability. Therefore, Panamalia could not have possibly breached Mrs. Feasy's inviolability under the Vienna Convention on Diplomatic Relations. Mr. President.
Judge Ray has a question for you, madam.
But let's go to the next step. She was indicted. It's a criminal offence. If she's found guilty, she could be sentenced to imprisonment. So how is that not so fundamentally incompatible with the objects and purposes of the convention? One of which is of course, to prevent retaliatory action by a government against diplomatic agents. It's all very well to say that it hasn't got to that stage yet, but if the criminal proceedings take their course, it will.
In the present case, it wasn't a summons submitted for the indictment of Mrs. Feasy, it was a summons to appear before a preliminary examination. And this very court also held in the arrest warrant case that only an enforceable document which would lead to the very arrest of the diplomatic agent would amount to a breach of inviolability. We do not deny if there would have been a document which would lead to the very arrest or detention and compulsory constraint of Mrs. Feasy to attend such a hearing, that would have led to a breach of inviolability. But in the present case, it is particularly evident as Mrs. Feasy didn't feel obligated to appear for such a preliminary examination, to enter evidence into the preliminary investigations. She didn't feel any act of constraint and any act of direct coercion to appear for such hearings.
So is your argument therefore that based upon this the government wouldn't or the courts wouldn't enforce a warrant in the future because of the indictment to make her appear before the court and possibly find her guilty and imprison her? Therefore she has immunity under the convention.
I'm afraid we do not know about the Pandemilian law enforcement regulations, and therefore we do not know what the consequences of not appearing to a preliminary examination really would have led to the enforcement of such an attendance at preliminary hearings. But the International Law Commission said that inviolability is every act that amounts to direct coercion, and coercion into the Black's Law Dictionary has been defined as compulsion by physical force or threat of physical force, intended to restrict another's freedom of action by threatening. And in the present case, once again, Mrs. Feasy didn't appear to the preliminary examination, and therefore she didn't feel physically forced and also didn't feel compulsory forced to attend such hearings.
Okay, please continue with the presentation. You have a few more minutes.
Yes, I will now proceed with Article 22 of the Vienna Convention on Diplomatic Relations. In the present case, the premises of the Telders Centre were used for commercial activities, which are considered to be incompatible with the functions of the diplomatic mission and therefore also its purpose. Consequently, the Telders Centre fails to meet the requirements set forth in Article 1 of the Vienna Convention on Diplomatic Relations, and therefore they do not form part of the premises of the diplomatic mission in Pandemilia. I have priorly established to your honourable member of the court that a notification to the receiving state is required, and also an application for consent, which Telders failed to meet, and therefore the Telders Centre does not enjoy inviolability and immunity under the Vienna Convention on Diplomatic Relations. If there are no further questions, I would now like to thank you very much for your kind attention and conclude with my argumentation.
Thank you very much. And I now invite your co-agent to continue in the presentation of the arguments of the respondent.
Thank you very much.
So you have the floor.
Mr. President, honorable members of the court, my name is Tobias Meyer, and it is my honor to speak on behalf of Pandemilia as second agent today. In the following 15 minutes, I will establish to this court that by suspending delivery of 10 military helicopters, Telders breached its obligations under Article 1, Paragraph 1 of the Military Assistance Agreement. Then I will continue by establishing that there was no justification of this breach. If it pleases the court, I will now start with my argument. The applicant argues that Telders is not responsible for the suspension of the military supply contract. This is clearly refutable. May I draw this court's attention to Article 1, Paragraph 1 of the Military Assistance Agreement. It specifically states that Telders will make available to Pandemilia equipment, materials, services, or other assistance in accordance with such terms and conditions as may be agreed. In June 2012, the Pandemilian Minister of Defense and Telders Helicopters Incorporation concluded such an agreement for the delivery of 12 military helicopters to Pandemilia. First, it is common practice of states to engage private entities as contractors in the defense procurement process. This can be taken example from the US federal procurement data for the fiscal year of 2015, the report on exports of military goods from Canada of 2015, or the report of the federal government of Germany on the export of conventional armaments within the first half year of 2016. Those reports include detailed lists of all private entities which have exported military goods to other countries. Second, it is also common practice of states to pass legislation which gives the state's governments control over the export of military arms to other countries. There is, for example, the US Arms Export Control Act, the Canadian Export and Import Permit Act, or the German Military Weapons Control Act. All those acts require private entities to obtain a permit before exporting military arms to other countries. While we cannot draw from the relevant facts whether or not TWIGA has passed a comparable legislation, the Military Assistance Agreement specifically states that the furnishing of military assistance may be restricted for imperative security reasons. By suspending delivery of 10 military helicopters, TWIGA executed its control over the furnishing of military assistance provided for by Article 1, Paragraph 1 of the Military Assistance Agreement. May I also draw this Court's attention to the fact that Pune did not make its counterclaim on the basis that TWIGA Helicopters Incorporation breached its obligations under the Military Assistance Agreement by not delivering. Pune made its counterclaim on the basis that TWIGA breached its obligations under the Military Assistance Agreement by suspending delivery. It would have been a matter of attribution if TWIGA Helicopters Incorporation had actively decided not to deliver the military helicopters without TWIGA having announced suspension before. However, this is not the case. We cannot draw from the relevant facts that TWIGA Helicopters Incorporation actively decided not to deliver the military helicopters. Whether for imperative security reasons or as a countermeasure, TWIGA suspended delivery as a reaction to Pundemilia's alleged previous wrongful conduct, thereby not fulfilling its obligations under the Military Assistance Agreement. There were no imperative security reasons which would have permitted TWIGA to restrict delivery. The government of Pundemilia wishes to submit that the term of imperative security reasons must be interpreted as having an exceptional character. This is confirmed by international agreements such as the Geneva Convention relative to the protection of civilian persons in time of war, which uses the term imperative reasons of security to create narrow exceptions. May I draw this Court's attention to Article 78 of said convention. If the occupying power considers it necessary for imperative reasons of security to take safety measures concerning protected persons, it may at the most subject them to assigned residence or internment. The International Committee of the Red Cross stated in its commentary, in any case, such measures may only be ordered for real and imperative security reasons. Their exceptional character must be preserved.
Judge Infante Cali would like to put your questions.
Yes, thank you. How can you, or how do you analyze the question of the entitlement to make an assessment on the question of imperative security reasons? Do you intend that TWIGA is not entitled to do that? Suppose that TWIGA has a relationship with the company which is not really proved. There is no evidence on this.
Yes, of course, Your Honor. If TWIGA invokes imperative security reasons for the purpose of suspending its obligations under the Military Assistance Agreement, it may assess the term. However, if there is a dispute, as it is now before this Court, of course it is this Court who, as a third party, is entitled to assess whether imperative security reasons were actually at hand. However, may I stress once again that the government of Pundemilia wishes to submit that the term must be interpreted as having an exceptional character. It may not be generally assumed for any kind of breach of obligations.
Please proceed, continue.
Also, according to Article 31, Paragraph 1 of the Vienna Convention on the Law of Treaties, treaty provisions must be interpreted within the context of the treaty. Pundemilia specifically agreed to use the military assistance for the promotion of international peace and security only. Punamilia never used the military assistance, thereby threatening any other state, most definitely not Twiga. All which happened, allegedly, is a violation of diplomatic law solely conducted by non-military means. In summary, there were no imperative security reasons which would have permitted Twiga to suspend delivery. Additionally, Twiga failed to comply with the constitutive procedure for treaty suspension. As per Article 67, Paragraph 2 of the Vienna Convention on the Law of Treaties, the suspension must be communicated to the other party. The instrument executing the notified measure must be made in writing. The press statement made by Twiga in May 2016 does not meet this requirement. Thus, Twiga failed to comply with Article 67, Paragraph 2 of the Vienna Convention on the Law of Treaties.
Judge Ray would like to put you a question. You have the floor, sir.
Yes, thank you. If the court decides that Pandemilia had breached the Vienna Convention on Diplomatic Relations by its actions against the ambassador's wife, Ms. Fissi, follow me on that. Hypothetically, if we decide that you were in the wrong there, how could that not be interpreted as an intentionally wrong act by Pandemilia against Twiga, thus inducing on their side a fear that Pandemilia would take retaliatory actions against Twigan diplomatic agents, their officials, and thus not allow them to argue that there were imperative security reasons to suspend the treaty?
May I ask you to rephrase your question?
Assume the court decides against you and finds that you have breached the treaty by violating the diplomatic immunity of the agent of Twiga, the wife. In those circumstances, why wouldn't Twiga be entitled to treat that as a countermeasure, a fear that your government would be taking retaliatory measures against Twiga, such as to allow them to take countermeasures and argue, or have a reasonable ground to argue that because of the fear that diplomatic agents are in danger of being arrested or retaliatory measures are taken against them, they cannot say that that constitutes, under Article 1 of the agreement, a imperative security reason, thus allowing them to suspend the treaty.
Thank you. The question is how to interpret imperative security reasons, whether it involves violations of diplomatic law or it does not. And
what I'm saying is, if we find that what you have done is so egregious, why aren't they entitled to say, well, this is an imperative security reason?
The fact is that if the violations of diplomatic law were assessed by this court or were decided by this court, and the fact that the Punamilian government wishes to submit that the treaty must be interpreted within its context, so we must look at the military assistance agreement and the fact that Punamilia never used military assistance to conduct those violations of diplomatic law. At the same time, this court held in the terror and hostages case, or found that diplomatic law is quite important to the international community, while we may stress at the same time the differences. In that case, an embassy was raided by armed students, and the diplomatic agents and the diplomatic staff was taken a hostage for more than 2 years. This is not the case here at hand. There was merely the institution of proceedings against Mrs. Fissi and the search and attachment of the Grotius Cultural Centre. So, if we interpret imperative security reasons narrowly, exceptionally, and at the same time within the context of the treaty, the violation of diplomatic law could not be accounted for or could not be considered imperative security reasons.
Thank you very much. I understand that you would like to make two submissions, that one is suspension for security reasons, and the other is suspension as a countermeasure. Could you elaborate on the conditions for lawful countermeasures?
Yes, of course. As this court held in the Gabčíkovo-Nagy project, countermeasures may only be taken in response to a previous internationally wrongful act of another state. As my co-agent has previously detailed to this court, Punimilia did not breach any of its obligations under international law. Even if this court held that Punimilia in fact committed such an internationally wrongful act, the suspension of delivery would still not be justified. This is because it does not meet all requirements of invoking countermeasures set forth by international law.
Elaborate on these other conditions.
Yes, of course. As this court also held in the Gabčíkovo-Nagy project, countermeasures must be proportionate in relation to the internationally wrongful act to which they are a reaction. Compliance with the military assistance agreement is of great importance to Punimilia. According to its preamble, the military assistance agreement was concluded to foster international peace and security within the framework of the United Nations Charter through measures which will further the ability of nations dedicated to the purposes and principles of the Charter to participate effectively in arrangements for individual and collective self-defense. As a member of the United Nations, Punimilia is of course dedicated to its purposes and principles. Unlike Twaiga, though,
what would you say that Twaiga was very much concerned that you have not respected inviolability of the diplomatic premises and immunities of a spouse of the ambassador. On the other side, you have just been deprived of receiving 8 helicopters. Isn't that commensurate when you weigh the interests and the rights of the parties? I don't think that 8 helicopters would critically endanger the security of your country, which is not a small country.
May I stress the importance of the military assistance agreement to Punimilia once again. Punimilia, unlike Twaiga, does not have many industries in the military sector. Without compliance with the military assistance agreement, Punimilia cannot participate effectively in arrangements for individual and collective self-defense. This greatly impairs Punimilia. At the same time, of course, we are for the alternative argument within an argument that would have to assume that diplomatic law was violated. But at the same time, it was mere institutions and proceedings against Mrs. Fisi, and the fact that she is the wife of the diplomatic ambassador in Punimilia, Twaigan ambassador in Punimilia. In light of this...
And what are the other conditions for lawful countermeasures?
The other conditions for lawful countermeasures would be the request to offer negotiations, or the offer to
offer for negotiations from the side of Twaiga?
There was, as a matter of fact.
Has your government replied positively?
It did not apply to Twaiga's second note verbal. However, in international law, there is no such requirement to respond to such an offer of negotiation. While at the same time, I would like to stress that we are here before the International Court of Justice today, which is a highly recognized institution of amicable dispute resolution.
We'll do our best to resolve amicably. Please, you have 1 more minute because we have given you a number of questions to close your submissions. Yeah.
Thank you very much. In light of this, the suspension of delivery is disproportionate. Accordingly, Twaiga failed to meet all the requirements of invoking countermeasures set forth by international law. May I emphasize to this court that countermeasures which do not meet all requirements of invoking countermeasures constitute internationally wrongful acts themselves. Lastly, Punimilia requests the court to judge and declare that by instituting proceedings against Mrs. Fisi, as well as searching and attaching the premises of the Grotius Centre, Punimilia did not breach any of its obligations under international law. On the other hand, Twaiga did breach its obligations under the military assistance agreement by suspending delivery of 10 military helicopters. I would like to thank you, Mr. President, and you, honorable members of the court, for your kind attention, and I herewith close my argument.
Thank you very much, sir. This completes the first round of argument of the respondent. And before opening the second round, I just wish to remind the parties that the second round should not be used for repetition of the arguments, but rather for addressing the arguments of the other party during the first round of argument. So I call on agent or co-agent, I see co-agent of the respondent who is going to take the floor, please.
To make 3 points of rebuttal to the submissions of the respondent. Firstly, Your Excellencies, the respondent has submitted that the requirement for notification in relation to the expansion of diplomatic premises represents customary international law. They, in support of this, cite US and UK jurisprudence, but however, they fail to cite any further national legislation in this regard. Furthermore, the Vienna Convention on Diplomatic Relations does not impose any requirement on the sending state, to notify in the receiving state. Therefore, the two parts of customary international law, that there must be this requisite state practice and that states must feel that they are obliged to do so, are not proven out here. There is no opinion juris and there is not sufficient state practice in this regard. In relation to the submission of the respondent on tacit acceptance of the reservation, as highlighted by the respondent herself, the VCLT, the Vienna Convention on the Law of Treaties, cannot be applied retroactively. And in this effect, to this effect, we highlight that Article 20, Paragraph 5 of the Vienna Convention on the Law of Treaties did not constitute a principle of customary international law at the time when Pundamilia's reservation was appended in January 1961. Consequently,
why? This does not reflect customary international law of 1961 or 62.
It did not reflect customary international law at that time, Your Excellency.
So your point is that it is rather for the respondent to prove the existence of such customary law, not for you, yeah?
Excuse me, Your Excellency?
That is rather for the respondent to demonstrate, to prove that that was the status of customary international law when they made their reservation, yeah?
Yes, we are contesting that it wasn't customary international law at the time.
So I understand. So in other words, it's not for you to prove that it is customary law, it's rather for them. And you are just denying the status of customary international law rule. Yeah?
Yes, indeed, Your Excellency. But the silence of the state party we would submit does not mean that it takes any position with regard to the permissibility, and thus Pundamilia's reservation has no legal effect in that regard. And so therefore, they breached Mrs. Fizzy's immunity from criminal jurisdiction when they appended that, when they attached her to criminal proceedings. Finally, in their submission, the respondents outlined that the Republic of Twiga has control, and indeed it does have control over the export of arms from their territory. The respondent has failed, however, to prove that this power has in fact, in this case, been exercised. I see that my time has elapsed, Your Excellency.
Well, you have a few seconds still.
Thank you, Your Excellency. Because the respondent, we argue, is taking liberty with the facts, we would argue that attribution has not been proven out in this regard. The respondent is seeing things that are simply not there and is interpreting the facts incorrectly, Your Excellency. Thank you for your attention.
Okay, thank you very much. I now invite the co-agent of the respondent to address the court in the second round.
Mr. President, honorable members of the court, in exercising Pundamilia's right of surrebuttal, we wish to follow up on that. First of all, to the requirement of notification. There is such a rule in customary international law requiring prior notification before establishing or expanding diplomatic premises. May I draw this court's attention to the incidents at the Libyan embassy in London in the 1980s. A police officer was shot outside of the diplomatic premises of Libya. The United Kingdom took that incident to greatly reveal its rights and obligations under the Vienna Convention on Diplomatic Relations. In result, it came to the conclusion to implement in its United Kingdom Diplomatic and Consular Premise Act a requirement of notification. At that time, there were 164 states having diplomatic premises in the United Kingdom. None of those states objected to that requirement and have complied with that requirement ever since. Therefore, the government of Peninsula wishes to submit that there is a requirement of notification in customary law. Also, as to the argument of tacit acceptance, once again, we would like to stress that this case and the reservation appended by Peninsula has to be governed by customary international law because the Vienna Convention on the Law of Treaties is not applicable. If we look at the existing customary law when Peninsula appended its reservation, we must look at the draft articles of the International Law Commission of 1962, in which they stated that if a state considers a reservation incompatible with the object and purpose of a treaty, it must object. Twiga never objected. Lastly, as to the argument of control and the lack of control, we wish to stress the point that Twiga announced in its press statement the suspension of delivery as a reaction to Peninsula's previous wrongful conduct. It therefore wanted to urge Peninsula to cease its wrongful conduct. With your permission, Your Honors, I would like to doubt that Twiga chose the suspension of delivery which it had no control over at all. If Twiga Helicopters Incorporation could have just merely ignored that suspension and could have delivered, there would have been no pressure at all on Peninsula. Therefore, we wish to submit that there was in fact control. But still, we would like to stress that it is not Twiga Helicopters Incorporation who breached its obligations under the Military Assistance Agreement. It was the state of Twiga by suspending delivery.
Thank you.
Thank you very much for your kind attention.
Thank you very much. I give the floor to Judge Infante Calvi.
Thank you. I had a question about the validity and the importance of the precedent you referred to. You have referred to the practice of a single country, although it is a country that is represented in the Security Council, but it is a country like many others. How this court should be bound by that practice regarding immunity and the scope of the premises that are covered by immunity and inviolability. Thank you.
Of course, Your Honor, the United Kingdom is just one member of the United Nations. At the same time, we would like to stress that there is similar practice in the United States. And we would also like to emphasize one more time that all states which have embassies in London complied with this obligation. And therefore, we would like to submit that it reflects customary international law.
Thank you very much, and this completes the second round of argument of the respondent. I wish to thank agents and co-agent counsel for the excellence of the argument. The court is now going to retire to start its deliberation. When we arrive at the judgment, the parties will be informed by the registrar about the time when the court will deliver its decision in this great hall of justice. Let me add that, of course, parties are not prevented from continuing in the negotiations and can reach out-of-court settlement. In such a case, the case would become moot and there will be no reason for the court to decide. As the court has no other business for today, this sitting is adjourned.
May I please ask everybody to join us for the group picture on the stairs of the Peace Palace. Well done, both teams.
Well done. Well done, guys.